Good evening, everyone, and a very warm welcome to one and all to the webinar on topics on secured versus unsecured financial creditors. So the speaker for first topic is Mr. Ravi Verma. He's a company secretary. And the second topic is COC decisions, commercial wisdom or commercial convenience. The speaker is Mr. Bandi Raviteja. He's an advocate. We take pleasure to have with us distinguished speaker, Sri C.S. Ravi Verma.
Thanks.
Sir, your presence and experience sharing will add huge value to this session.
Thank you, Pavitra. So we welcome you all to this 55th webinar series of webinars conducted by IPNet. And in this webinar, we will be taking two topics. One is secure financial creditors and COC commercial wisdom or commercial decisions. And now I request the members to kindly watch the IPNet introduction video.
In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
Good evening, everyone. I am delighted to welcome you all on today's webinar. The first topic is secured versus unsecured financial credit. And the second topic is COC decisions, commercial wisdom or commercial convenience. The speaker is Mr. Bandi Raviteja. He's advocate. So this is the 55th webinar in the series of webinar organized by IPNet, your own platform for sharing knowledge and experience of the IB ecosystem in India. We are privileged to have eminent, esteemed speakers, two Ravis. Both of them have subject expertise and practical legal insight in the topics. We can have a great learning, knowledge sharing. I extend my special thanks to Shri Ashish Makhija ji, President of IPNet, for bringing all of us together on this robust IPNet platform. The membership link is available in the chat, and we can look forward to those who IPNet has become a vibrant community for insolvency professionals across India, fostering continuous learning, collaboration, and professional growth. We are committed to supporting IPs through expert-led learning initiatives like webinars and study groups, practical guidance on IBC-related challenges, and a dedicated member portal offering comprehensive resources. For those who are already part of IPNet, thank you for your support. For those, I encourage you to join the dynamic and ever-evolving network. Membership details are available in the chat. Thank you all for being here. Let's make this session insightful and rewarding.
So much everyone for joining this 55th webinar organized by IPNet. And on this very auspicious day of Dhanteras, first of all, I would like to extend my gratitude to all the members for sparing their time and joining on this date. And a happy Dhanteras to all. And we are so delightful that although Ravi sir is not feeling well, but he has joined to address and address our audience because it was a pre-commitment from his side. So we are so honored and welcome him on this particular topic which has been assigned. Ravi sir, you will be able to take up the sessions.
Savand, I will thank you so much. First of all, for giving me this opportunity. Probably I will try my best to make for few minutes because I regret my inability owing to my heavy cough and cold, which is again a viral in Kolkata. So, Savand, it's pleasant to take this as a invitation, and rather I'll be looking forward because this is very really a tempting one decision as well and a much needed when we are discussing on the role of creditors as well as the expanding role of IBC. So if you permit, I'll for a few minutes I'll continue like as you wish.
Yes, sir, we would be happy to hear from you based on your experience and knowledge. I think
Yeah.
members will be able to get something from today's sessions.
Thank you so much. Thanks.
So,
That's really nice of you.
so
So
let me,
like
sir, with your permission, sir, I just like to read your profile with.
yeah, sure, sure.
Thank you so much. So, members, today we have with us Mr. Ravi Verma, sir. He is a company secretary, having more than 16 years of experience in statutory and regulatory compliance under the Companies Act and SEBI regulations, merger and acquisitions, legal operational and governance, secretarial and legal compliances, stakeholder managements, besides other SEBI regulation, Companies Act and RBI. He has proven acumen to evaluate complex, multi-dimensional situation and compliance tools, insightful knowledge of the Companies Act 2013, SEBI regulation, FEMA provision, and other allied laws. He has made stirred effort of the organizations by defining policies or framework, strategy, processes, and procedures, engaged teams, and dealt with processes, risk, and existing control. Ravi sir, we are so honored to hear from you today. We have heard you from multiple seminar, multiple forum, and looking forward and learning a lot from you. It's such an honor to introduce you today.
Yes, sir.
Thank you so much.
Of
Thank
IPNet
you.
also, we are very happy to have you. But once again, extremely sorry for troubling you.
No, no, I rather is very much thankful to all of you, IPNet team and Shavant, especially being the near one and dear one. It's like even I when I was informed the topic I must say is out of the way. The role which we are going today discuss, like Savant introduced me in the very nicely and aptly. So I would like to thanks for that also. Like coming straight away when we are discussing today, secured and unsecured creditors. Like first of all, I will say that when IBC has come based on the UNCITRAL principle, the main intent and the main logic of IVC was to ensure that it should come for the health being of a corporate debtor. So many a times I keep suggesting everyone, like, let's be out of the mind the parity or the differentiation between the creditors. The first and foremost principle of the entire IBC or the crux, while I will take my brief few minutes and will also share some of two or three cases also where creditors have been treated, you can say on equity and the differentiation. But prior to that, I would just say that what IBC is that is basically a health check. You can say a test. So it's like a ECG where the doctors or where the you can say people wants you to survive. They do not want at least like you to come out with a different report. They want you to come out with a report which is in favor of a peasant. And that's what the IBC testameter is. And if you look at the IBC, the enactment, UNCITRAL, first and foremost thing that has arisen when two creditors were taken apart, like financial and operational. People were saying that these creditors, sorry, people were having a view that these creditors, financials and operational creditors, are being differentially treated, and hence it may be a breach of Constitution of India. Later on, Supreme Court has come out very clearly that there is no breach, there's not a differential treatment, is a rather repayment of your rights. So repayment of right cannot be treated or cannot be set aside with the your differential treatment. Now question comes, then where is the myth that arises between the secured and unsecured creditors? If we look at the IBC, section 3 and then 10 very clearly defines that IBC is for all creditors, be it of financials, operational, secured, unsecured. Because if you know, the creditors have been defined as basically indicate the notion indicates that the financial creditors and operational indicators, though may be the new, but they are also covered. And for the sake of transparency, you can say IBC has taken care to define it into two categories, financials and operations. But nonetheless, our gambit still remains the same on the secured, unsecured, because the moment IBC has come, I will say is a simple funda was that earlier there was a straight away voluntary liquidation. But today there is no voluntary liquidation. It has reduced like substantially post IBC because the reason being again, the doctor here do not want the patient to die, means IP or the you can say regulatory as well. They want their patients to survive for the best, survive with a good health, and that is what IBC has arisen. Now question comes, how comes this IBC change the picture for the financial creditors and the financial debtors? So obviously, debtors are the one which they have also the route under the IBC code to go for the claiming their rights. Even there are many cases like Swiss Revens. Many of us have been aware about that, where preferential treatment were provided to the financial creditors over operation. And this was the reason where Supreme Court was challenged that there are two rights. Now question comes, financials operation is clear. Why secured creditors are too much worried? So I will say in short, what happened is that section 53 of this IBC code, which allows for the liquidation proceedings in a waterfall mechanism that grants the priority to the secured creditors. So this way, my secure creditors becomes happy that okay, see, I'm coming on the top of the sheet where I'll be getting the you can say priority along with the workman's due. But if you look at the intentions, so I will say intention wise it backfired because inter se priority amongst the secured creditors themselves was not mentioned, leaving the first charge on the priority charge holder uncertain about their right. So, even somewhere you will find there is a first charge or second charge basis. There also we get confused what actually the first charge and second charge can be. Right? Still, there are, I am sure that many of you can make it interactive and can discuss also because today also different judgments are coming, setting the precedents for us to understand what can be the overriding treatment or what can be the claim treatment for the first charge holder or the second charge. So even if I look at the other way, the one school of thought thinks that there is they consolidate. What basically they do consolidate the owner's priority over the rights. That the first. And what the second group of thoughts does, they supports a framework that links the credit and the security. Because they believe that see, all the creditors are connected by a common collateral. That's the first principles of any extension of a law. So even if you look at this second school of thought, I will say that's a right that they are supported by a common collateral. Even in fact, you look at the SR Steel case, the Supreme Court first verdict, which has come out, that has also set a precedent that yes, it is more so with the collateral, their rights, and that's what has been decided in the SRST. But again, we have seen something different in the Amit Metallics, right? Because Amit Metallics case has shifted its focus from first charge to the second charge, and they have again become on the priority. Means you can say party. And there are certain verdicts, I will say still, if there, these are, I will not say these are the final verdict. These are the state level verdicts. Like one is the rainbow papers of state tax officer. The another one is the Paschim Manchal. I will share these summaries with Savan and IP Net team also, where there has been a debate. What was the debate? Whether the government comes under the secured creditors or not, which is defined under section 3 subsection 30, because it doesn't include the government authority if you look at the definition. Right. So while state tax officer in the case of a rainbow was having this view, this view was also limited, you can say, or curtailed by the Paschim Anchal Vidyut Nigam. What happened there is that they said this this IBC Act itself override the provisions of the Electricity Act. So even if your areas are due there, that cannot be taken cognizance here. So while I will say, that this creditors dichotomy situation remains uncertain in the IBC regime, I would like to say that, by limiting the administrator's ability to obstruct the enforcement of securities during a resolution, what happens is that the other laws, like say, for example, in the other countries, like I would like to correlate UK, European countries, what they have taken a strong instance in defending the priority rights of secured creditors. They are saying the creditors might be divided into two categories. And probably, going forward, India will also take a precedence from the US chapter, which is a defined bifurcating rights of secured and unsecured for the sake of people to understand and to make it simple for everyone that yes, these are the rights remain to the secured creditors. Because we have seen section 52 where the secured creditors start claiming, we have seen 110, how they goes into the flow of recovering the repayment and what are the proceedings during the liquidations. But still, in India, we are predominantly dominated by the precedents. Like in some of the other, even the secured creditors can forego their rights. Right? There are precedents. They can forego their rights in a special situation. What can be the special situation? Where they settle over, where they agree with the corporate debtor. They have the rights to relinquish even. In those relinquishes cases, whether that priority can be given to the unsecured or not, that remains, the questions remain, the answer remains unsecured, uncertain as well. So in India, probably if you look at the situation, I will say again, it is more so by the, you can say, court precedents only. And the twist has come to it by the another new personal guarantor definition. Because, personal guarantor also, whether people do agree that personal guarantees are the one who agrees to a lender that, okay, that we are agreeing to a lender for a particular debt of a borrower. Typically, a corporate entity, generally, they will ask for this. But what can be the personal guarantor's obligation and what can be the consequences? Those section 95, 100 and outlines. But still, the question is that whether that can take a shape, whether they can be considered in the, you can say, concurrent start of the CIRP, we can consider them as a principal borrower and debtor relationship. So these are something cases you can refer to the Athena Ventures case in that case, where it has been presented. The personal guarantor is not, however, given the opportunity to present their case to protest the filing of insolvency application, they remain their right as if like a secured creditors. So it varies from cases to cases. Things are very complicated, and I would be happy to discuss it some other day down the line to have this navigations of secured, unsecured creditors challenges in details. With these words, I would like to take a rest here because again, considering my ability, I once again regret for missing the same. I would not excuse, I would not say sorry. Rather, I would say I would regret this opportunity.
No, no, sir. We are
I will
so thankful that you have joined today.
Thank you so much, Al. Thank you so much, Sawan.
So, sir, since today's we had line up these sessions, like we have also one more speaker for the day who is going to take the subsequent session. And on behalf of Sir IPNet and our team also, we would like to extend our gratitude and thanks to you that you have joined this session and addressed our audience even after you are not feeling well. So we are so thankful for you for joining, sir. And we look forward, sir. We'll invite you once again to address our
Yeah,
audience.
I will be happy to have it some other day because seriously, I'm going to miss it. That's true.
We are so glad, sir, that you accepted our invitations and you have addressed very quickly and very. I can say that whatever the address which we have given to our audience, it was a quite concrete and up to the mark which our audience experience is having. So once again, sir, thank you so much for joining.
Thank you. Thank you so much, Savan.
Thank you, sir. So, with the permission of our moderator for this session, and we will move ahead and for the subsequent next sessions, which will be taken by our another speaker for the day, Mr. Bandi Ravi Teja ji. Ravi Teja ji, can you please?
Yes.
Can you just introduce the
Yes, ma'am. Yes,
speaker?
ma'am. Yes, ma'am. I'll read his profile.
Can you or Pavitra introduce the speaker?
Sure, ma'am. Sure. So, Ravi Teja ji, if you have joined, please confirm.
Yes, sir. Hi.
Thank you.
Hi,
Thank you.
everyone.
Yeah.
Good evening, sir. Good evening.
So, with your permissions, I would like to read your profile for the understanding of our
Oh,
audience.
that would be my pleasure. Thank you so much.
Thank you. So, distinguished audience, today we have with us Mr. Bendi Ravi Teja, who is a distinguished commercial law expert and founding partner of Veera Legal LLP, a full service litigation and advisory firm operating across Hyderabad, New Delhi, Bangalore, and Amravati. He is an alumni of Damodaran Sanjeev National Law University, Visakhapatnam. He further pursued the prestigious postgraduate insolvency program at the Indian Institute of Corporate Affairs, Ministry of Corporate Affairs, and is eligible to be registered as an insolvency professional under the IBBI. He also ranked second in the postgraduate diploma in financial services and legislations from Nalsar University, Hyderabad. Mr. Ravi Teja sir is a practice spans across insolvency and commercial litigations, corporate restructuring, banking and regulatory dispute, strategic commercial advisory, arbitrations, white collar crime, startup advisory, and media law. He has advised and represented clients like clients before NCLT, NCLAT, high courts, commercial courts, and various regulatory bodies. His clientele including public sector banks, scheduled commercial banks, NBFC, ARCs, Telangana State Horticulture University, IT and tech startups, and other professionals from finance, media, and technology sectors. At the intersection of policy, finance, and legal practice, he brings a rare blend of strategic insights and litigations precisation, making him a sought after voice in forum on insolvency and commercial law, dispute resolutions, and financial regulations. Raviji, we are so thankful and we are so honored to have you today. Now, I would request you to kindly take the session from here onward. Thank you.
Thank you so much, sir. Thank you for your kind words. Thank you so much. It's a pleasure for me to interact with all our distinguished guests. Most of them are insolvency professionals and advocates and company secretaries and chartered accountants. It's my pleasure to be part of this session. The topic is also very dynamic in nature. COC decisions, whether it is COC's commercial wisdom or commercial convenience. It's a very fitting topic. So before I start the session, I would just want to go through the history of the commercial law in detail, or like very briefly. So before before the advent of the laws and other things, like what are the modern economies that we see today, the situation of trade and commerce were quite different in the ancient history and the ancient world. The commerce and trade is a very important facet, and it goes back to the dates of the early civilizations. From the advent of the invention of the wheel, the civilizations have started, and they've culminated by agriculture, trade, and commerce has gone. At that point of time in ancient and even throughout the medieval history, if we see the economic history, the governments, that is the monarchs at that point of the kings, have a very limited role in regulating the commerce. They were majoritarily concerned about their taxation and treasury aspects, but very limited with regulating that of, with a very limited role of widely with whom to do business and how to do business, and very not in detail. But if we want to start the topic as we see today, then we must speak of someone very important who played a very key role in the commercial law at large. That is Lord Mansfield. Lord Mansfield was the Chief Justice of King's Bench during 18th century. We often call him father of commercial law. What was the practice of that day in 18th century was that law followed the merchant. So there was no codified law to say so that these would be the practices, these would be whatever the practices, those were adopted by the the merchant or the trade groups. That was the law of the day. Then Lord Mansfield has developed this law merchant, what we call, and we consider him to be the father of the commercial law on principle to principle basis. And thereafter, the common law principles have evolved. Then the British started to legislate most of the laws, starting with the Contract Act and then the Companies Act, then their rule in India, and we have adopted the same common law principles that as even today we see. Then after our independence, we have slow down the economy because our governments involved to be more socialism, where with no role of a king, then there comes the democracies, then there are new socialist concepts or socio-economic theories that were evolved, where the government used to run the businesses. Then at a point of time we opened our markets, the liberalization has happened. Then we see, then the economies have paced up. Now, coming to the subject where we need to confine ourselves to the IBC oriented, we have the earlier SICA in 85, and then the SICA was repealed by legislation in 2003, but not yet notified. So, only by the advent of IBC, it can be said that the SICA has been repealed. Though SICA repeal act was enacted in 2004, but the government has notified its appointment date to be in 2016, only after the insolvency and bankruptcy. Now, what were the early instances? What is the nature of the commercial wisdom, or how the courts have seen the commercial wisdom prior to the advent of IBC, if we may see? Then I found the most celebrated judgment of Mayor Muftlal versus Muftlal Industries Limited, where it was in a different context, but Supreme Court has observed very interesting things on commercial wisdom. It was, the issue there was with reference to the Old Companies Act 391, the scheme. Regarding the scheme, there was an issue. Then Supreme Court has observed and held that we have to limit ourselves, and we cannot delve into the issues of commercial wisdom of the shareholders in approving a scheme or adopting any principles with reference to the scheme unless they are not violated by the law. This was what that we have before us, before the advent of the IBC. Now, in the context of shareholders only, the Supreme Court has held that we will not interfere in the decisions of the COC. We are not interfere with the decisions of the shareholders in approval of any scheme unless it violates any statutory principles. That means any law established by the Parliament. That was the main railguard that was put forth by the Supreme Court, that unless there is a statutory violation, there is no necessity for any court. Back then, the High Court cannot sit in an appeal over a decision made by the shareholders in the commercial wisdom. That was the principle that we have. That is the premise we have when we started the IBC. When once IBC started, there was an interesting departure from all our earlier laws. What we have adopted in the IBC scheme is what we call as a creditors in possession model, that upon the commencement of insolvency, the CIRP on the ICD, the powers of board of directors stand seized and shall vest with IRP, RP, and thereafter with the liquidator as well, subject to the process in which we are dealing with. Now, when such powers are vested with IRP, now ultimately when company is a solvent one, all the decisions would be taken by the board, subject to the other provisions of the Companies Act with reference to the other decisions made by the EGM. The majority of the business decision shall be taken by the board of directors. Now, when board of directors has been suspended and can be vested with an individual professional who we call under the IBC as an insolvency and an interim resolution professional, or the resolution professional being a stage of the case. Now, can every decision be taken by the IRP or RP? Then the code prescribed that there are certain decisions which will be straightly and strictly be taken by the committee of creditors. Now, the committee of creditors, we all know, will be constituted by the financial creditors. Where there are no financial creditors, with the operational creditors. Where there are no prescribed operational creditors within the 18 largest, then all the operational creditors. Now, the committee of creditors have, the IBC has vested most of its decisions mostly in the nature of commercial wisdom with the COC. We can see many provisions where there is an absolute prerogative. I may use the word prerogative because there is no other authority which can take that decision, including the IRP. Even so as to say that Section 28, when it has enumerated a list of things to be done, especially and exclusively by the authority of the COC with not less than 66%, then it also says that where any decision is not in parallel with the approval as stipulated under 28, those decisions shall be void. So the statute has made it very clear that certain decisions during the process are completely vested with the creditors. That is the reason why we say that this is a creditor in possession model, where the decisions are driven by the creditors themselves because they are the ultimate beneficiaries of the entire process. Now, there were getting of judgments by Supreme Court, NCLATs, and NCLTs. Mostly, I'm dealing with the Supreme Court and NCLAT judgments, so that they would be in a sacrosanct nature and there would be a binding effect to those judgments. Now, going by the precedence of the arrangement of the sections, the first thing that we can see where there is a commercial wisdom that we invested by the code is that Section 12A, withdrawal application admitted under Section 7, 9, or 10. Now, the provision says that prior to constitution of COC, it is the applicant's decision. Upon constitution of COC, 90% of the COC must vote in favor of a withdrawal. And once it is voted, then the company would be put out of the CIRP. Now, there's an interesting judgment, which is Vallal RCK versus Shiva Industries Holding. It's a Supreme Court judgment of 2022, where it was held that when 90% or more of the creditors in their wisdom, after due deliberations, find it well within the interest of all the stakeholders to permit a settlement or to and withdrawal of CIRP, the adjudicating authority or NCLAT cannot sit in an appeal over the commercial wisdom of the COC. The interference would be warranted only when adjudicating authority or NCLAT finds the decision of the COC to be wholly arbitrary, irrational, and deos of the provisions of the statute. Now, as earlier I was telling, the principle that was upheld in Mayor Muftilal, where with respect to the commercial wisdom of a shareholders, there also the principle is the same. The principle is that unless it is in violation of a statutory provision or the statutory scheme, no courts can sit in an appeal over a commercial wisdom. This is the principle. And this principle is time and again upheld by the NCLAT. Now, the first judgment that we see where the commercial wisdom has been discussed is that of K. Shashidhar versus Indian Overseas Bank, where it is clearly upheld the sanctity of the commercial wisdom, that commercial wisdom is non-justiciable and no court especially that of NCLT or NCLAT, can sit in an appeal where COC has decided in a particular way, subject to that their decision is well within the compliance of the regulation of the provisions of the code and the regulations. And then we have multiple judgments. When then we move on to the provisions, then we have Nagitlang Dhar versus Panna Pragati Infrastructure. I'll just share this ketino of judgments. I've just prepared some 20 odd judgments, which would be beneficial for all our distinguished members, so that these things that we see every day on a day-to-day basis when we deal with our own cases, where it again said that it was a Supreme Court judgment where it says that the commercial wisdom of the COC has been given paramount status without any judicial intervention for ensuring completion of the process within the timelines prescribed by the code. Because what we need to mind at this juncture is that the objectives of the code, when the code was enacted by the parliament, it has four objectives: the value maximization, the maximization of value of the asset within a time bound manner, so as to strike a balance between the stakeholders and the interests of the stakeholders. These are the paramount objectives of the code. So that when a decision is made by the COC, it is not for the judicial interference unless there are certain things where it violates the provisions of the code or the regulations and regulations, the regulations prescribed by the IBBI. Then we have, well, then if we move on to the provisions, the next provision we will have the appointment of RP. That is also an absolute prerogative that was being prescribed to the COC, where the 66% COC can decide either to appoint IRP as an RP or replace the IRP with a new RP. That decision was, there was a case where the Committee of Creditors of Leel Electricals Limited versus Leel Electricals through IRP, where the NCLAT held that the decision of the IRP or RP or replacement of IRP by another RP falls within the prescribed ambit of Section 22, which is based on the commercial wisdom of COC and which is not amenable to the judicial review. And when COC has passed the resolution with requisite majority, it is not proper to say that the legal rights of the IRP has been infringed. This matter has arisen from IRP challenging the decision thereby. Then we have also, then going by the order, then we have the Section 27 where the replacement of RP, which is also squarely falls into that box where the COC have absolute prerogative to take a decision, and NCLAT has held that no, it cannot be challenged once COC has resolved someone, especially the replacement of an existing RP with that of a new RP. Then if we move on, we would find the majority of judgments more in the provisions of Section 30-31, where with respect to the submission of a resolution plan. Now, there was an interesting resolution plan. The interesting things that would come where is when a resolution plan has been submitted by the COC, can an adjudicating authority sit in an appeal? Then the Supreme Court has made it very clear in Maharashtra Seamless versus Padmanabham Venkatesh and others, where that once the resolution plan has been approved by the COC and submitted by the resolution professional to the adjudicating authority, the adjudicating authority ought to cede the ground to the commercial wisdom of the creditors rather than assess the resolution plan itself. This is one of the interesting case where the question also arises whether the resolution plan has to be, if a resolution plan which is equivalent to liquidation value, that be fair, or can such issues be dealt by the adjudicating authority? Then the Supreme Court has said no, that is the commercial wisdom of the COC, and the code has, with the parliament, well within its wisdom, has made the law in such a way that the decision on approval of a resolution plan shall be taken by the committee of creditors, and there was no equivalent provision where that it is amenable to the amenable to either appeal or to set aside, apart from the statutory scheme that is propagated, which is that to a checklist whether the scheme is viable or feasible. This is whether the plan, the resolution plan, is compliant plan. Especially these are the things that the adjudicating authority ought to look into, whether the plan contravenes any other laws which are in force. These are the limited realm where the adjudicating authority can step upon. And one more thing that we need to see is that the Supreme Court also held that these adjudicating authorities, which are NCLTs essentially, are not courts of equity. They are the tribunals which are the creation of a statute. So they must limit themselves within the four corners of the statute, where the statute has prescribed a particular manner of how a resolution plan has to be evaluated at an approval stage. So they cannot sit in an appeal or assess the approved resolution plan of the COC. Then there was an interesting case, Gail India versus Ajay Joshi, resolution professional of Alok Industries, where I'll just read out for the benefit of our viewers that what the NCLAT has held, that there is no embargo for the classification of OCs into separate or different classes for deciding the way in which the money is to be distributed to them by the COC, because of the fact undoubtedly they do not have undoubtedly they do have the subjective final discretion of collective commercial wisdom in relation to the quantum of money to be paid to a certain category or individual category of creditors, of course nicely balancing the interest of the stakeholders and the OCs as the case may be. They have used a very interesting nomenclature, a terminology, which says the collective commercial wisdom. Now, it would be a thing that a particular creditor taking a view is the commercial wisdom of that particular creditor. But a COC is a collective establishment of the all the creditors. Now, any decision taken by the COC is a collective commercial wisdom where it is binding on all the processes, all the things, including a manner prescribing that a classification of OCs into different categories for the payment to be finally made under a resolution plan. Then there was another interesting things that we on a case to case basis, where a COC has approved a resolution plan, where the resolution plan proposed that the resolution applicant has proposed that upon the ultimate approval of the resolution plan by the adjudicating authority, the nature of the business would be changed. Now this was put under challenge. Now, when a COC has approved a resolution plan, knowing its viability and feasibility and other things, for example, the COC would be aware that this company is not operational for a very long time, or it's the existing the licenses which were there with it were lapsed and not extended. And then it has decided to approve a plan where they have proposed to change the nature of business. Now, NCLAT in this judgment, Jaideep Ghosh versus Neeraj Agarwal, held that the change of the nature of the business can be permitted, as COC in its commercial wisdom has accepted the plan after examining various factors, especially the CD not carrying on business activity for a very long time, or a license got lapsed and not renewed, etc., and upheld the approval of the COC as well as the approval of the resolution plan. Now, then we have a interesting judgment where categorically Supreme Court has laid down the importance of the commercial wisdom. Kalpraj Dharmshi versus Kotak Investment Advisors. It's a Supreme Court judgment of 2021, where the first thing it has upheld is the commercial wisdom of the COC has been given paramount status without any judicial intervention for ensuring completion of the stated process within the timelines prescribed by the court. Because one of the objectives, if you remember, if you see the preamble, is that the resolution must be in a time bound manner. The second interesting aspect is the financial creditors are fully informed about the viability of the corporate debtor and the feasibility of the proposed resolution plan. The opinion expressed by the COC after due deliberations in the meeting, as per the voting shares, is a collective business decision. As in the earlier decision, also we have seen that what they've referred is a collective commercial wisdom. The NCLAT has taken that nomenclature from this judgment of the Supreme Court. Then it has interestingly identified that the legislature has consciously not provided any ground to challenge the commercial wisdom to of the individual financial creditor or their collective decision before the adjudicating authority, and that the decision and there emerges the principle, and the decision of the COC's commercial wisdom is made non-justiciable. Appeal, and again it goes on to say, appeal is a creature of a statute, and that the statute has not invested jurisdiction and authority either with the NCLT or the NCLAT to review the commercial wisdom exercised by the COC of the approving resolution plan or rejecting resolution plan. The commercial wisdom of the COC is not to be interfered with except the limited scope as provided in the section 30 and 31. Either 30, the procedure prescribed how an approval happens before the COC, and what happens after the approval with the adjudicating authority, where it has to see the limited aspects, whether such a plan contravenes any law of the land or other things. Then there is another interesting judgment of J.P. Kingston Boulevard Apartments Welfare Association, which is NBCC, where it has given an interesting judgment, where it says that the role of the COC is akin to that of a protagonist, giving finality to the process subject to the approval by the adjudicating authority, who takes the key decisions in its commercial wisdom and consequences thereof. Now let us move. Now we have seen what all are commercial wisdom, because we all are professionals. We know what commercial wisdom is. Now I have enumerated. I did a little research to find out what does not amount to a commercial wisdom, because that would be a very important thing to discuss to justify my title, whether the COC's decisions are commercial wisdom or a mere commercial convenience. Now there comes a what interesting judgment I've found, Rajneesh Jain versus Manoj Kumar Singh, where it has said that where then an interesting thing the NCLAT has upheld. The COC, where the question that was before the NCLAT was that in this particular case, the COC has changed the nature of few of the creditors from FC to OC. They've passed certain resolutions. Now, COC has upheld that the committee of creditors has no role in deciding or changing the status of a financial creditor or an operational creditor. And even if you decide a particular way that this particular creditor is a financial creditor and he no longer stands as a financial creditor, he's from today the operational creditor, such a decision shall not be a commercial decision. And it said that the COC, such decision of the COC can never be treated and exercised under its commercial wisdom. So it is justiciable. It has struck down the resolution that was passed by the COC of changing the nature of the creditors. Then there was an interesting another case where Periyaswamy Palani versus Radhakrishnan Dharmarajan. It was a very important judgment with respect to the EMDs and other things, where there was an important highlighting part with respect to valuation, where a valuation report was submitted with mere numbers and there was no detailed report that was being provided thereunder. And basis that COC making a decision, then it said that the existence of a valid and accurate valuation report is a sine qua non for the COC to exercise its commercial wisdom. So what it indicates is devoid the valuation report with a valid valuation report where there is a detailed reporting of the valuation, any decision taken with respect to a resolution plan, then that will not amount to the commercial wisdom of the COC, because it was not informed decision. It cannot be treated to be an informed decision. Now, then there is one more NCLAT judgment, Jindal Power Limited versus Dhiren Shantilal Shah, where the decision was challenged on the ground that though COC has taken a decision for value maximization of an asset on the ground that
क्योंकि उनके पास इतनी जगह नहीं होती है बच्चों के साथ जाने में, और वो बच्चे में मतलब इरिटेटेड होते थे, प्रेफर की लिमिटेड लोग हैं, इतना होता है 1 घंटे में वो हैंडल कर सकते, उनकी कैपेसिटी लोग हैं। पार्किंग से लेके मेन रोड पे पार्किंग, मतलब एवरीथिंग इज अ हेडेक फॉर क्लिनिक गाय ओनली।
Yes, sorry, there was some interruption. Yeah. So we were
Hello,
discussing
Bati sir.
the NCLAT judgment, where in Jindal Power Limited versus Dhiren Shantilal Shah, where it was said that though under the guise of the value maximization, can COC take a decision which violates or contravenes the principles, the provisions of the code or CARP regulations, the NCLAT held that no, such a decision which is in contravention of CIRP regulations cannot be permitted and cannot be treated as a COC's commercial wisdom. So that what is happening, or what happened there was, as the COC has taken a decision under the guise that it is a value maximization, but there was a contravention of a CIRP regulation. Now that was under challenge, and NCLAT has rightly upheld that such a contravention cannot be justified just because it has been taken by the COC and it is into the objective of the value maximization. It has said no. Then there was this judgment of Kotak Investment Advisors versus Krishna Chamadia, where it was with respect to the duties of the resolution professional, where it held that the act of resolution professional to accept a resolution plan after opening of other bid cannot be justified by any means and is a blatant misuse of the authority invested with the RP to conduct the CIRP. It was further observed that any material irregularity in exercise of powers by RP, even with the approval of the COC, in the conduct of the CIRP, cannot be treated as an exercise of commercial wisdom. So, even a contravention by an RP later ratified by COC cannot also be considered to be a commercial wisdom which is non-justiciable. Once there is a violation of the code or this or the regulation, then it automatically falls within the ambit of the judicial review. Now there is another NCLAT judgment of Express Resorts and Hotels versus Amit Jain, where this is a very interesting thing, where the COC has approved the resolution plan and the resolution plan has been submitted to the adjudicating authority. Later it was prayed to the adjudicating authority that we want to remand the resolution plan back to the COC for its consideration. Then the NCLAT said that no, it cannot be done. Once the resolution plan is approved and submitted to the adjudicating authority, subsequently COC cannot turn around and pray to the adjudicating authority to send the plan back for consideration. COC being satisfied that the financial offer given by the resolution applicant is satisfactory, exercised its commercial wisdom, and then approved the plan. And then even COC cannot be allowed to change its view, since it is bound by its own decision of approving the resolution plan. So this becomes these are the guardrails that we put to the commercial wisdom. Even COC being approving its own plan, it is bound by its own decision. And then there are two other decisions which I'm referring. One is with respect to the liquidation estate, where uh, where the question was with respect to the provident fund and the PF amounts which were not provided by the proponent, by the resolution applicant, and it was approved. Then it said that because though it was approved by the COC in its commercial wisdom, but the elements of the plan are in contravention with that of the law of the land, which is the PF Act. So it is in violation. It cannot be said that COC's decision is of paramount, and it has set aside to that extent, where it also upheld that there is no contravention, there is no inconsistency between the PF provisions and the IPZ, and it has upheld that till the date of transfer, the amounts to be paid by the by the resolution applicant. And then this judgment would be helpful to all of us. This is regarding a fixation of the fee of the resolution professional, where interesting thing has happened. An appeal, a CIRP has been admitted. There was the CIRP's admission order was challenged under appeal. In appeal, while disposing and by setting aside the by CIRP, it has directed the adjudicating authority to evaluate the CIRP cost and the RP fee. Accordingly, the adjudicating authority has allowed the CIRP cost, and it has directed to pay a particular amount to the to the interim resolution professional as a fee for that interim 3 months period under which the CIRP was ongoing. This was challenged by the RP, by the IRP, saying that the NCLT was not considerate in fixing the resolution professionals fees. Let the COC decide this matter before disposing of the appeal. Then the NCLAT has upheld that this decision, the fixation of a fee of the resolution professional, is not a business decision, depending upon the commercial wisdom of the COC, and it has held that this does not fall within the ambit of the COC's commercial wisdom, and it will not entertain the appeal. Sir, this judgment is called Devarajan Raman versus Bank of India Limited. It's an NCLAT judgment of 2020. Yes, sir. Somebody was just asking the judgment. So these are the brief compilation of the judgments I have prepared. I just want to conclude the session by saying and justifying my topic, whether the COC's decisions are COC's commercial wisdom or the commercial convenience. So long the decision is within the ambit or within the guardrails of the provisions of the code and regulations, they are non-justiciable, subject to that power is vested by the court with the COC. For example, 12A, 22, 27, all the enumerated list under 28. And then we have the approval of the resolution plan or the resolutions for going for an early liquidation, or the resolutions even in the or early resolutions, or these things where the code has particularly vested that power or the decision making authority with the committee of creditors. They are well within the ambits of the we can say that these are commercial wisdom. And once these things have been deviated, then there is a contravention of CIRP regulation or the provisions of the code. So even so, being it in the interest of the majority or a value maximization, a violation of law, they cannot take the benefit of the commercial wisdom. And once they violate the law, it can no longer be treated as a commercial wisdom beyond the judicial review. The courts can intervene, the NCLT's, NCLATs, or any other court can intervene and set right the process. I will just compare this thing with today's technological advent, what we see in AI, artificial intelligence. There is a concept of guardrails. What happens in artificial intelligence is to for the technology, the engineers have put guardrails to the artificial intelligence, these things, large learning models, or the chat GPT or Gemini or anything. So what they call is rail guards. So they whatever question we ask, they will not deviate from these rail guards. That is only for the safety and to behave properly, so that the right decision will be arrived, and they will be not be deviated from what the objectives are. The objectives under IBC are value maximization in a time bound manner, balancing to have a balance between amongst the stakeholders. Now these things cannot be devoid of the contravention of the law. These things must be in compliance with the laws that has been stipulated. just because to achieve a value maximization, I cannot go or I cannot overrule a provision and say that, see, ultimately I'm getting higher value, so that I violated the law cannot be a justiciable act. Then that would be subject to the judicial review, and such a decision cannot be said to be a COC's commercial wisdom. Then that will become merely a COC's commercial convenience. Thank you so much. I also love to hear from my distinguished viewers, so that they can also have their own experiences in their own practice, so that to add on to the subject today that we are discussing. Please, sir, I invite the members to just add on to the topic, so that we can have a beneficial discussion, so that what they have seen in their own practice, so that we would also be benefited from their experience. Thank you also.
So any member wants to discuss on this topic? We would like to hear from you all. Anyone?
Yeah, if any question is there, we'll request any of the delegates if they can come forward and discuss with the speaker itself.
I'm Ramesh from Hyderabad.
Yes, sir, please.
Even while approving a resolution plan, the conduct of COC beyond recovery is generally in doubt. They are only bothered about whether the recovery is there or not. So are they really going into the merits of reviving a company without giving consideration to their recovery? In fact, recently we heard a very senior official of the government saying that the IBC code recovery should be incidental and resolution should be the major point. But you see the action of most of the COCs in the reverse mode. So in the light of this, I think Mr. Ravitej has presented very well the commercial wisdom and all that. So his opinions or legal jurisprudence, if anything, on this aspect, which needs to be tested.
Yes, sir. Yes. I think I'll just add on to that thing. I will only say that the bankers have not come from the hangover of the SARFACI yet, where they only see the asset, asset, and selling the asset. That hangover must go, and they see that the revival and rehabilitation of the business happens. And I will say that we shared recently such a revival. so there we really saw a good revival beyond beyond a recovery of the debts. So, Savan sir, I've just prepared a small compilation of these case laws. I'll
Yes,
just
sir.
share it. I'll just share it to you in a PDF mode, so it may be circulated to all of members that we would be benefited from these case
Yeah,
laws.
yeah, that will be great help actually.
Thank you so much. Thank you for this wonderful opportunity to interacting with all of you. Yeah,
Thank you. Thank you very much, Ravi. Thank you for an insightful session and very, very comprehensive definitions from whatever the interpretations from the judiciary on the collective wisdom of COC. So now we understand it is comprehensive collective wisdom of the COC. So thank you.
Thank you so
Thank
much.
you very much. And I request Pavitra to kindly give vote of thanks. And next week we will have the webinar from IP IPNet East.
Yes.
So
Madam, may I
request
come in
all
one
the
minute,
members
please?
to kindly join.
Sonu ma'am has, I think, some question.
Yeah.
Okay,
Ravi
okay.
sir. Yeah, thank you so much, sir,
Yes,
for
ma'am.
allowing.
Yes.
Ravi sir, may I request you to please share your list of the citations that you have done, given us
Yes.
such wonderful citations, and some of them are so relevant, which we might have missed it,
Yes.
in our due course of our journey. So I
Yes.
would
Yes.
really request you if we could get a list of your citations
Yes,
and
definitely.
ratios that were laid down.
That would be my pleasure. I'll just share a PDF with Savan sir and Swasni ma'am so that
Yeah.
it could be circulated amongst our groups.
Yeah,
Thank
thank
you
you,
so
sir.
much.
Thank you.
Yes.
And so it
Thank
was
you.
wonderful for hearing from you. Thank you so
Thank
much.
you. Thank you so much.
Thank you.
Happy Diwali as well to all our members and the organizers. Thank you so much. Happy Diwali.
Diwali, everyone. Happy Diwali, sir.
Thank you. Thank you, Ravi ji.
Yeah.
Yeah. So, shall we conclude, Suhasini ma'am?
Yes, ma'am.
Yeah.
Vote of thanks with a vote
Yes,
of
yes. Yeah. So, it is an honor to extend the vote of thanks for today's webinar. Today's event has been a good learning experience for all of us. So far, regarding secured versus unsecured creditors, COZ commercial wisdom. First and foremost, I extend my heartfelt thank to our distinguished guest speaker, Sri C.S. Ravi Verma. Instead of being ill, he has, tried to join and give some insight on the topic. And then Sri Vendi Ravi Tejaji for sharing their profound insights on a very critical and practical concepts in IBC. We are very grateful to both of you for sharing your time, wisdom, and experience. I would like to express my gratitude to our IPNet President, Mr. Ashish Makhija ji. Ashish sir, your commitment and visionary leadership has made IPNet an exemplary initiative and a platform of great significance for insolvency professionals pan India. Thank you for being a guiding light to all of us. A special note of appreciation goes to IPNet South for successful smooth conduct of this webinar. Special thanks to the invaluable contribution of transition and the technical support teams. Their seamless coordination and tireless efforts behind the scenes ensure smooth conduct of the webinar. Our gratitude to all the participants who joined us today. Instead of being festival, you have all you have shown your enthusiasm, active engagement, and thought-provoking contribution has truly made this event special. And last but not the least, our sincere thanks to Suhasini ma'am from IPNet South for taking out time from her ongoing courses for ensuring the success of this webinar. Thank you, one and all, and happy Deepavali.